I'm speaking to Jeremy Sirrell, partner at Palmer Solicitors and specialist in motoring offences. Jeremy, I want to talk to you about driving disqualification offences. So just to clarify, what offences can cause a motorist to be disqualified from being able to drive?
Well, very simply, any offence that is endorsable carries with it an unfettered discretion for the magistrates to disqualify. There's a huge gamut of offences and offences such as excess speed, running a red light, no insurance, careless driving. Any endorsable offence at all gives the magistrates the power to disqualify. In the vast majority of cases, of course, they won't, but the power is there. There are some offences where disqualification has to be imposed by law. For example, driving with excess alcohol carries with it a minimum period of disqualification of not less than 1 year, and dangerous driving also carries with it a minimum period of disqualification of not less than 1 year. So they're the offences that can lead to disqualification, pretty much any motoring offence. But in addition to that, of course, there are situations that can lead to disqualification, because many people face disqualification as a result of totting up 12 points or more under the totting provisions of the Road Traffic Act. So the most minor offence can lead to that person just nudging over that 12-point boundary and then being subject to disqualification of not less than 6 months under the totting provisions.
So what happens once a motorist has been disqualified?
Once the motorist has been disqualified, they cannot drive on any public road within the United Kingdom, and if they do so, that's a serious offence which is likely to lead them to being sent to prison. That doesn't prevent them from driving abroad, except of course they won't have a driving licence, they won't be able to drive lawfully abroad either, but they won't be disqualified from driving abroad.
So are there any special routes that a motorist can go down in order to prevent disqualification?
Yes, and the route that you need to go down will depend upon the kind of disqualification that you are facing. For example, probably one of the most common kinds of disqualification would be within the magistrate's discretionary powers, and the most obvious example of that would be excess speed. If you're caught travelling at 105 miles an hour on the M25, you're probably going to be disqualified. Now, the route that you need to go down in that instance is a route of general mitigation, and that is that you want to put before the magistrates reasons that persuade them that either they don't need to disqualify you at all, or that they only need to disqualify you for a short period of time. And in fact, in that kind of disqualification, very much it's a question of damage limitation, so that a longer disqualification, if not avoided, then can be brought down to a shorter period, which is wearable and may well avoid somebody losing their job, for example. In cases of obligatory disqualification, then the only way obligatory disqualification can be avoided, other than by running a trial and winning the case, is to run special reasons. So, for example, with a matter of driving with excess alcohol, disqualification is obligatory. But if one only drove the vehicle a very, very short distance in order to get it out of a dangerous position and into a parking space, that's been held to be a special reason to avoid disqualification. So you might want to run a special reasons application in order to avoid disqualification there. If, however, you are facing disqualification under the totting provisions, then what you need to do is to do something quite different. Then you need to run what's called an exceptional hardship application. And an exceptional hardship application is where the magistrates are persuaded that you, the driver, would suffer exceptional hardship were you to be disqualified. And it's difficult to run these. They must be run with an understanding that the hardship must be real, not mere inconvenience, and it must be exceptional. And very often people who run these do so on the basis that they're going to lose their job and therefore they shouldn't be disqualified. And very often those arguments simply lose because they've not been prepared properly, or they've not taken into account all the factors which they need to put before the court. So running an exceptional hardship argument is something that needs proper preparation, but it can be done to avoid disqualification if there are proper reasons there to do so.
Jeremy, thank you.